Hi, welcome to MediatorPodcast.com, a podcast and video series about mediation, negotiation, and collaboration. My name is Melissa Gragg, and I'm a valuation expert and divorce financial mediator in St. Louis, Missouri. I specialize in divorce and partner disputes, and today we're going to be talking about business disputes. And Margeaux Thomas has worked with entrepreneurs and small business owners, specializing in commercial, landlord, tenant disputes, business partnership disputes, contract disputes, franchises, partner issues, non-competes, non-solicitation. She's actually located in the DC area. And today we're going to talk about moving from arbitration to mediation in business disputes. Welcome, Margeaux. How are you?
I'm doing good. Thank you for having me, Melissa.
Awesome.
I'm not sure a lot of people appreciate the nuances or differences between arbitration and mediation, but basically arbitration is binding. It's like going to court. There's going to be a person who says, you know, you're right or you're wrong, or you owe this much money, or this is how we're going to resolve this, and you are bound by it. And there's usually very little appeal opportunities after they come up with an outcome, which means that if they come up with the wrong outcome or they don't, review the facts, there's not much you can do about it, which is, I guess, good to some people. I mean, if you're winning, but there are people who judges have bad days and they make mistakes, and arbitration can be a difficult process because there aren't a lot of options if you are on the short end of that stick and do not get the outcome that you want. But it's also very expensive because when people go to court, your tax dollars are usually paying the judge's salary. But in arbitration, you're paying an hourly rate for the judge, and the judge is usually very expensive. So, and that judge is going to be involved in every aspect of the case. So every motion, every discovery dispute, the scheduling order. And then there's also this administrative body that helps facilitate arbitrations that you have to pay for as well. And there's like an arbitration coordinator on every case that just makes sure that things flow smoothly and everybody gets the information you need. You pay for them too. So it becomes very, very expensive. There's a sliding scale based upon how much is in dispute of how much you even have to pay to initiate an arbitration. So you could have to pay $5,000 to even get into arbitration, whereas the filing fee for a federal court complaint in Virginia is like $400. So it is a huge difference in the amount of money that is spent in arbitration. So I think that there has been some shift in understanding of the disadvantages of arbitration. So people are leaning away from that. And mediation is a voluntary process. There's nobody is going to come in and say, you have to do this. You're not going to be bound by it. You have to reach an agreement that you are okay with. Both sides have to sign on the dotted line. The mediator has no ability to force an outcome on any of the parties. And that's why the parties need to be involved in that in good faith. They have to be there. I mean, they need to be there wanting to reach a resolution and put this behind them. If one of the parties is not and has some ill motive, then it is not going to be successful. But so a lot of agreements we see now, especially operating agreements, say that before you can go to court and file your lawsuit having anything to do with the business or your business partner or whatever your dispute is, you need to try to mediate the issue. And